Hello, everybody. Welcome to this final panel of the conference entitled Occupation and Legal Restraints. If I can invite, David Kretzmer is already with us, and Anna Anderson, if I can invite that. Yeah, hi. Thank you for joining us, Anna. Our third speaker, Professor Mara Rifkin, will be joining us in a little while, so we're going to just go ahead and start. And our first speaker is Professor David Kretzmer, who will be speaking about the occupied territories and the Israeli constitutional order. And let me just tell those who are not familiar with Professor Kretzmer yet that he is Professor Emeritus of International Law at the Hebrew University of Jerusalem, where he was the founding academic director of the Minerva Center for Human Rights. He has been a visiting professor at Columbia University, Tulane University, University of Southern California, and the Fletcher School of Tufts University. In 2009-10, he was the inaugural fellow at the Strauss Institute for the Advanced Study of Law and Justice at NYU School of Law. In the spring of this year, he's a visiting scholar at the Taub Center for Israel Studies of New York University. Between 1995 and 2002, Professor Kretzmer was a member of the Human Rights Committee that monitors compliance with the International Covenant on Civil and Political Rights as vice chairperson of the committee in 2001 and 2002. His main fields of research are constitutional law, human rights, and the law of armed conflict. His most recent articles have been on the use of force in international law, the use of lethal force against suspected terrorists, the law of belligerent occupation, the place of occupation in the West Bank of the West Bank in Israel's constitutional order, on which we will hear, and the influence of the constitutional regime change and the occupied territories. His most recent book, written together with myself, is The Occupation of Justice at the Supreme Court of Israel and the Occupied Territories, a second edition that came out with Oxford University Press. Dave, the screen is yours.
Thank you very much, Yael, for that introduction. I'm trying to say the topic today is the occupied territories in the Israeli constitutional order. Now, the next slide, please.
Sorry.
I don't understand. View of most constitutional lawyers in Israel, there's a clear division between Israel's constitutional order regarding the territories that were part of Israel before 1967, including now Jerusalem, to which Israeli laws have been applied, and the territories occupied in 1967. So the Israeli constitutional order can be described as a fairly liberal democratic order, which has some faults, but that is its fundamental basic understanding. And you and Eyal Gross spoke about this morning, and what I'm saying now is quite connected to what he said. Under this traditional view, the rule of Israel over the territories occupied in 1967 is not part of Israel's constitutional order. So we have a nice democratic liberal order, and on the side we have some kind of occupation. Now, the question is, on what is this based? Well, first and foremost, on the idea that the territories are subject to a regime of belligerent occupation. Second of all, that Israeli law has not been applied in most of the territories, with the exception of East Jerusalem and the Golan Heights, and the notion that Israel's presence there is temporary and will end with some kind of political agreement, with the generally accepted view of the international community today to be that sometime in the future we're going to have a two-state solution. I challenge this view, and I argue that after 57 years, which is 75% of Israel's existence as an independent state, this has been the situation that Israel has held these territories. The traditional view is no longer tenable. And there are political and legal factors which lead me to that conclusion, and I'm going to present them today. Can I have the next slide, please? Okay. So the first issue relates to the legal status of the West Bank. Now here we have the most complicated situation, because according to the jurisprudence of the Supreme Court of Israel, the regime on the West Bank is the regime of belligerent occupation as determined under international law, and especially customary international law is reflected in the Hague regulations of 1907. The government takes the line, well, yeah, we apply the regime of belligerent occupation, but it does not really apply de jure. We're only doing it out of a question of policy, out of what they call de facto, but de jure, the regime of belligerent occupation does not apply to these territories. But the truth is that Israel has no intention to withdraw from these territories. The 2022 coalition agreement signed between the main party and the government, the party of Prime Minister Benjamin Netanyahu and one of the other main political parties in the coalition, states that the belief that the whole of the land of Israel, which includes, of course, the West Bank and probably the Gaza Strip, belongs to the people of Israel. And because of this belief, Israel will impose its sovereignty over the West Bank. The only question is being a question of timing, which will be decided by the Prime Minister according to international developments. Then, of course, the policies with which I will deal a bit later are certainly not consistent with the temporary nature of Israel's presence on the West Bank. And finally, we have a very interesting letter written by the cabinet secretary in June of last year in response to a letter written by Adala, NGO which deals with the rights of Palestinians in Israel. And they, after the new government was formed, they wrote to the government saying that some of the steps that the government planned, such as legalizing, as it were, settlements established on the West Bank without government approval, were contrary to the law of belligerent occupation. The cabinet secretary wrote a letter in which he said, well, what are you talking about? The law of belligerent occupation does not apply. The West Bank is not occupied territories. It's territory which belongs to us. And out of policy, we are very nice and we apply some of the laws of belligerent occupation de facto. So the idea that the legal status of the West Bank is a status of belligerent occupation, which is accepted by the whole international community as part of the jurisprudence of the Supreme Court, does not, in fact, reflect government policy. And as we'll see, government policies are not consistent with this regime. Then we come to the state borders. Well, for various reasons, when Israel was created by the Declaration of Independence on the 14th of May, 1948, no mention was made of the borders of the state. As people here may know, under the resolution of the United Nations General Assembly 181 of the 29th of November 1947, the General Assembly recommended that Palestine, which had been under the British mandate, be divided into two states, an Arab state and a Jewish state, with a corpus separatum in Jerusalem. And they even drew the boundaries of the suggested two states. And Israel, while it accepted the notion of partition, wasn't very happy, to put it mildly, with the borders which were allocated to it. And for those reasons, especially, they did not mention the borders of the state when they declared independence. And since that time, no official document has ever defined, no law has defined the borders of the state. But there was a government decision in this November 1967, 6 months after the 1967 war, in which Israel assumed control over the West Bank and Gaza, that the maps of Israel in future would not show the green line, which was the line on the armistice agreement map between Israel and Jordan, dividing up former Palestine, which Palestine, or Eretz Yisrael in Israeli terms, and the line was shown dividing the Jordanian and Israeli forces by a green line, and this has been known since then as the green line. It is not since November 1967 been shown in official maps of Israel. If you look at the official maps of Israel, you'll see the West Bank totally included. And then we do have a law of the Knesset, our parliament, that the executive may apply Israeli law in any part of the land of Israel that is held by the IDF, the Israel Defense Forces. Next slide, please. Then we have the main issue, and that is the issue of Israeli settlements and settlers in the West Bank. Close to 500,000 Israeli citizens are now settled in towns and villages spread out over the whole of the West Bank, and this does not include the people who are in that part of Jerusalem, which was not part of Israel until 1967. These settlers all enjoy the rights under Israeli law that they would enjoy were they to live in Israel, and by a variety of legal mechanisms in which I can't go into for lack of time now, but Israeli law has de facto been applied in the large settlements in which Israelis are resident. In fact, on the West Bank, we have two legal systems. We have one legal system which applies to the Palestinian residents, inhabitants of the West Bank, and we have a totally different legal system which applies to the Israeli settlers on the West Bank. Then we have the issue of what are called state lands, and that is a misnomer, a term used for public land, which under the military order is actually supposed to be government land, but it's all land which is not private land, and which is taken, the control of which is undertaken by the military government on the West Bank. And that land is being used to the extent that it has been allocated for private use. It has been allocated almost exclusively, more than 99.75%, for the use of Israelis and Israeli settlements, and not for the use of the local Palestinian population. Israel has shown no regard for the restrictions on the use of public land in occupied territory under Article 55 of the Hague Regulations. And now we come to the status of the military commander. In June 1967, the military commander issued proclamations in which he declared that all governmental power was now in his hands. And this was under the idea in international law that if the previous government can no longer fulfill its functions in the territory over which the army has effective control, the army must assume effective control and fill the vacuum of the government. And so up to this day, theoretically, all the power, the governmental power in the West Bank is in the hands of the military commander of the West Bank. And he is the legislative body. All military orders on the West Bank are promulgated by the military commander, and they have the effect of law. But at the same time, the military order, or commander, is an organ of the Israeli executive branch of government. And as a member of the executive, he must further its policies. And this becomes very, very clear when it comes down to the matter of settlements, because the government decides on the settlements. The government decides whether to establish Israeli settlements or where to establish Israeli settlements, at least those settlements on which the government decides. There are over 100 settlements in which there was no official decision of the government to establish those settlements. But the settlements which have been established with government approval, and then the military commander must take all the steps in order to fulfill that, with no question that he could ask, well, is this legal under my powers under international law? So the military commander virtually has a dual role. On the one hand, he is the commander of the West Bank. He has all governmental powers in his hand, even according to the jurisdiction of the Supreme Court. He is bound by customary international law, the law of belligerent occupation. But on the other hand, he has duties as a functionary of the Israeli executive. And then the question is, well, which becomes first? And I think that's very, very important for the present discussion. And according to the Supreme Court, it's clear that his duties under constitutional law come first. And this Yale and I wrote about in our book on the Supreme Court and the occupied territories, because we showed that there are certain cases. If we take the case, for instance, dealing with the construction of the separation barrier or the wall on the West Bank, and the court asked, well, what power does the military commander have to take land on the West Bank? And one of the arguments was, well, he has a duty under the Israeli constitutional law to protect the rights of all Israelis living on the West Bank. And therefore, he could use, under that constitutional duty, he had the power to take land which is of Palestinians, which is protected under the law of belligerent occupation. Could we have the next slide, please? Now we come to the place of international law. Israeli law has followed the distinction of English law when it comes to the place of international law in the domestic legal system. And the distinction is based on the distinction between customary law and treaty law. Customary law is part of the common law of the land, which will be applied by the courts unless it's inconsistent with parliamentary legislation. However, treaties which bind the State of Israel because they have been ratified by the State of Israel will not be part of the domestic legal system unless they have been incorporated in Israeli domestic law. And the reason for this distinction is a constitutional reason. Under Israeli law, as it is under English law, the treaty-making power in Israel is in the hands of the executive branch of government without the need for parliamentary approval. And so the idea is, well, we cannot allow the executive to change the domestic law of the land by making treaties. And so in order for a treaty to be part of domestic law, it needs parliamentary incorporation. Now, when the court first began deciding cases dealing with the occupied territories, it by instinct adopted this distinction between customary and treaty law as regards the obligations of the military commander on the West Bank. But in fact, this distinction should not be relevant on the West Bank, because in the West Bank, all power is concentrated in the hands of the executive. And we do not have a problem of circumventing the legislator, which does not really have power and is not the legislative body on the West Bank. And however, when this argument was raised before the Supreme Court of Israel, and I would mention that I was the person who raised it, and the argument that the distinction is not applicable in occupied territories, basing this on quite a number of English authorities, the Supreme Court said, no, well, even if that is the situation in England, it is not compatible with our constitutional law. So once again, in deciding on the question relating to the West Bank, constitutional law is the main issue. And then we come back to the issue that we have constitutional law as a grounds for restricting the right of Palestinians. It's been used as a basis for placing restrictions on the property rights of Palestinians, which face much stronger protection under the international law of belligerent occupation than they do under Israeli constitutional law. For lack of time, I won't go in detail into the further issues, but we do have Knesset legislation that applies to the West Bank and regards the West Bank as part of the State of Israel. And then we have a further issue that the Israeli courts have jurisdiction over cases on the West Bank regarding the land on the West Bank, which under general rules of international law, the proper forum for dealing with cases regarding land is the forum in the place of the legal system in which the land exists, and yet it's here in the hands of the Israeli courts. So let me just mention some conclusions, if I can have the last slide, please. And so I say that the conventional wisdom of Israeli constitutional lawyers and the Israeli Supreme Court is that Israel's constitutional regime can be described without relating to the West Bank. I've argued with close to 500,000 Israeli settlers living in the West Bank, the view that Israel's control over this area is merely a temporary situation that will end if the political agreement is removed from reality. However, it allows the view's adherents to maintain the vision of Israel as a very liberal democratic state. The wider, more realistic view that I present here calls this vision into question. Thank you very much.
Sorry, okay. Thank you very much for this, Dave. And I'm glad to see that
respondents self-reported harm. So on survey questions about whether your house was damaged or destroyed, family members injured or killed, and so this is the river, and this is dividing the city in two. So East Mosul liberated before West Mosul. We see that much significantly higher levels of collateral damage in West Mosul, as indicated by the red dots here. So respondents in West Mosul were 13 percentage points more likely to report damage. And that estimate is corroborated also by satellite data. So we find a similar difference when we look at satellite imagery comparing East and West Mosul. And when we then look at attitudes toward the Iraqi armed forces, as well as the U.S. military, the results are consistent across all the different. So these apply both to the Iraqi forces and then for the U.S. military that was leading the coalition. We find that respondents in West Mosul had significantly more negative attitudes toward the military. So they were around 8%, 8% more likely to believe that U.S. and Iraqi forces were likely to kill innocent civilians, our measure of military legitimacy there. And we also find similar differences. We find very strong differences in levels of looting by ground forces between East and West Mosul, where it's about 10%, civilians in West Mosul are about 10% more likely to report that they witnessed looting by ground forces as compared with East Mosul. And then an important finding, we think, is that these differences persist even after controlling for individual level harm. So if we take two people, one in East Mosul, one in West Mosul, who experience the same levels of harm, so house damage, member of household killed and injured, comparing them, the person in West Mosul still has more negative attitudes toward the Iraqi forces and the United States. And we think that reflects that military legitimacy is about more than just physical harm. So we think it's because they experienced this overall very different way of fighting war that was much less restrained and expressed just at a policy level, much less concern for protection of civilians. And these results also, there's some interesting findings here on perceptions or blame. So the extent to which people blame different armed forces for the harm they experienced. And we find, so some of you will know if you follow this battle, it's an important case study in urban warfare. The Islamic State became much more abusive of civilians as the battle moved to West Mosul, and as they sort of hunkered down in their final stronghold, they were using civilians much more heavily as human shields, and they were also mass executing civilians by the hundreds as they were trying to flee Mosul. So terrible, terrible, terrible abuse of civilians by the Islamic State in West Mosul. But nonetheless, we're seeing in the results that respondents in West Mosul are actually significantly less likely to blame the Islamic State for the harms they experienced than they are to blame the Iraqi forces or coalition actors, which is just really striking given what we know qualitatively about the change in ISIL's treatment of civilians. So yeah, these results are quite concerning that we have in West Mosul this sharp shift to greater reliance on air power, less disciplined ground forces, and we're finding that the Iraqi forces are perceived as less legitimate, and ISIL is being blamed less than in East Mosul, where we have this more disciplined, restrained operation led by elite ground troops that was extremely costly for Iraqi forces, resulted in a casualty rate of 75%, but the military was perceived as much more legitimate there. So just a couple of quotes to close out here. So qualitatively, we went I had done interviews in Mosul in 2017 and 2018 around the battle and then the period after that. And our research team went back this summer to try to follow up on some of these findings. And we found some real differences. So when we asked civilians both about sort of questions about just cause and just conduct, so do you think that sort of the battle for Mosul, the overall objective of this war was kind of just or righteous to begin with? Not everyone agreed with that. So interestingly, a lot of civilians thought there was a strategic decision made to trap ISIS in Mosul rather than allowing them to retreat toward the desert in Syria, even though ISIL had actually tried to negotiate at one point sort of a safe retreat. And the decision was made to trap them in Mosul, and the cost of defeating ISIL would be sort of the destruction of the city of Mosul. That was very obvious to civilians, and they objected to it. And so civilians were very aware. A lot of people said that the army made a mistake leading ISIS to West Mosul instead of toward the desert. They could have led them to, they could have. There was an alternate sort of plan B scenario where ISIL would have been defeated in sort of what was called a kill box in the desert, heading towards Syria. So anyway, so concerns about whether or not the objective of the battle in West Mosul was just. And then also concerns about the conduct of individual armed forces. So I'll just make a quick note here. One thing that was distinctive, and then I'll conclude, the elite ground forces, the special forces in East Mosul were multi-ethnic, multi-sectarian force that's representative of Iraqi society broadly. The population of Mosul is majority Sunni Arab. So 99% of the survey sample was Sunni Arab. The federal police who were used to liberate the West Mosul were predominantly Shia, and so had a lot of animosity with the civilian population. And so we had lots of just observations. Some of this is driven, I'm sure, by ethnic sectarian bias, but real concerns about discipline, concerns about discrimination and sort of laws of war violations by these less trained, predominantly Shia militarized police forces, observations about looting, stealing, all kinds of misconduct. So we see both sort of in West Mosul concerns about the overall sort of whether or not the cause of the war is even just. Was it right to destroy the city of Mosul for the sake of defeating ISIL? And then also concerns about the conduct of individual members being less restrained and less disciplined than those in East Mosul. So, okay, so just a couple of theoretical implications here. We think these findings suggest, again, getting to the importance of civilian agency. So we want to take seriously that civilians have choices to make among different armed actors. We think also the intent behind harm matters. So civilians they are able to perceive whether harm is caused intentionally or negligently. So we heard lots of stories in East Mosul about these elite Iraqi forces who took great personal risks to save civilian lives. So, someone who took a break from fighting to bring someone's grandfather to the airport for treatment, for example. And I think this suggests that both, if you just wrapping up very, very briefly here, because I'm taking too much time, but so civilians are sensitive not only to physical harm, but also to sort of moral injuries. They care not just about the harm that was caused, but how it was caused and why. So the fact that there was an alternative potential option for defeating ISIL in the desert that would have caused less harm to civilians and mattered, and is something that really affects public opinion. And there's also, and I think, so we also think there's an implication here that part of why the Iraqi military was perceived as more legitimate in East Mosul is because they suffered so many casualties and because they had sort of, quote, skin in the game, or their willingness to take enormous risks to and suffer casualties was evidence of their commitment to protecting civilians. And we think that actually signaled to civilians something about their concern for civilian lives. And it's a reason why. So we heard a lot of this kind of in East Mosul, that part of why the Iraqi special forces are so valorized and really sort of respected there is because they were willing to sacrifice their lives for civilians. And in contrast with West Mosul, where the operation was largely fought by airstrikes with much lower risk to Iraqi combatants. So I'll stop there. I'm sorry it took a bit longer than expected, but I'm really happy to be able to engage with this group. And any questions that we don't have time for today, please feel free to follow up with me and my co-authors by email here. Thank you.
Okay, thank you all three of you for these interesting presentations. We have a number of questions for all of you, so I think what might be best is let me present you with the questions, and we'll start with David, who probably see the question to him, as he may have had that time to think about it, and that leaves some time for Anna and Mara. So the question for David is from Maria Varaki from King's College in London, and that is, if there was a future edition of The Occupation of Justice, what would be added or edited there? So I don't know if, you know what, go ahead and answer that, and then we'll move on to Anna and Mara.
It's a question. I don't think it's connected with my lecture today, because our book that I wrote together with Yael, as you know, does not relate to the whole typification of the regime on the West Bank, but specifically to the way the Supreme Court of Israel deals with questions from the West Bank. So I'm not sure that I would change anything there. But since we finished the book, which is how many, 4 years ago, Yael, there have been a lot more judgments of the Supreme Court, and that may affect what we would have to write in the new edition. But I wouldn't write anything different given to my view on the connection between constitutional law and the status of the occupied territories.
Okay, Mara's question to you again from Tamar Mikidal. When you talk about military legitimacy, you seem to be focused on legitimacy in the eyes of the population in the territory where the military fights are, But one may also ask about legitimacy in the military's home population, which may be distinct in transboundary conflict, or the global population, and the metrics may obviously be very different across contexts, although all may have an important impact on militaries. So how do you understand the interaction between them? Do the other populations also have impact regarding the chance for conciliation? And if I could just add a question of my own, you note that, well, two questions. One is about the idea of agency of civilians, and I'm wondering what the normative implications are, given that civilians are not actors, are not intended to, they're not supposed to be actors, and they're not even supposed to be affected by armed conflict, although we know that they are. But if I understand correctly, then the research supports the distinction. If you say it's not the absolute, it's not the harm in absolute terms, but the justness of the cause and the conduct, that seems to support the legitimacy of the idea of proportionality and necessity, because the experiment shows that the law is actually the law that ought to exist.
Thank you so much for these excellent questions. So I would say that absolutely, this paper doesn't. I'm very interested in differences in perceived legitimacy of militaries between sort of the population, the military's country or public, and sort of the country that's affected by the conflict. This is something I'm studying in an upcoming. I'm trying to just get the link to this project. Project with Noam Lubal and Amichai Cohen and Yanina Dill, that's on cumulative civilian harm, where we're going to conduct surveys both of populations in Iraq and other conflict-affected settings, and then also publics in the United States, Europe, and Israel about their attitudes toward militaries. And yeah, I think it's really part of why I think we've seen this shift, at least in the United States, towards so much more reliance on air power, is perhaps because of the ways in which sort of war is reported to our public. So I am not certain now that there's a lot of concern. My husband's actually a veteran of the wars in Iraq and Afghanistan, and there was a huge amount of concern about protection of U.S. troops, or sort of concern about American casualties during those wars. And I'm not sure, now that we're seeing more and more reporting on the effects of conflict on civilians, I do wonder, and I think it hasn't been sort of fully studied, how information about the toll that war takes on civilians in these contexts affects public support for military operations. Anecdotally, we see some with everything happening in the U.S. and protests. I mean, I think there's a lot of concern there, but that's something we'll study in these surveys. And then to the second question about, so I think to Yael's question about are we finding evidence of something like sort of lay understandings of proportionality and necessity in these interviews? I think we are, where civilians do seem to differentiate. So in East Mosul, where civilians did also experience some pretty terrible harms, property destruction, injuries, deaths, they seem to recognize that those harms were for a legitimate purpose, or that those harms were caused accidentally, unintentionally, by forces who were sort of otherwise exercising a lot of due care and restraint, in comparison with West Mosul, where there was a real feeling that the harm was being caused sort of needlessly. So I do think, yeah, and actually Yanina Dill, my co-author in the new project, has other work on this, but we think that people may have some lay intuitions around sort of that there may be a basis in kind of lay intuitions for proportionality and necessity. I'll stop there.
Let me ask Dave one question from Ben Clark, again from Australia. If I understand correctly, Professor Kretzmer's conclusion is that political will dictates the legal framework that should be applied in the West Bank. As the Knesset executive variously support, expand, and tolerate settlements, the legal order should reflect this reality, irrespective of the law of occupation. If political will flips, so does his conclusion. And I think, Dave, that you saw this on the Q&A, so I won't read the entire question, but is that...
No.
How would you respond to that?
I make it quite clear in the paper that from my point of view, it's clear that the legal system that applies on the West Bank is the law of belligerent occupation. My question was not what norms apply, but how Israel's rule over the West Bank should be perceived in describing Israel's constitutional order. I do accept that if some kind of imagined state in the future, Israel were to make agreement and hand over the West Bank to some other political unit, be it the Palestinians or whoever it has been, then there would be a change in the constitutional order. But I'm talking about the constitutional order as it is at the moment. And my whole notion is that it is incorrect to try to describe Israel's constitutional order as a nice, liberal, democratic order where for 75% of the time that Israel has been an independent state, it's ruled over a population who has absolutely no rights in the political system, and that has to be taken into account in describing the political system.
Thank you. Okay, so we have one more question from Ben Clark tomorrow, which I think you're answering, but if not, I'll send it over to you on email because we do need to conclude on time. Let me just take this opportunity to speak in my not entirely identical hat as the editor of the Israel Law Review and remind participants that the Israel Law Review regularly publishes articles based on submissions that have been made to the IHL conference. So if any of you are interested in submitting your article to the Israel Law Review, where it will undergo peer review in accordance with our regular procedure, you're more than welcome to do that. Danny will be sending an email relating to this later on. You're welcome to contact me directly if you have any questions. And specifically, let me just mention, related to the topic of this conference, is the special issue that the Israel Law Review published on the constitutional overhaul in Israel, an issue that came out at the end of 2023. So you're all welcome to read it. And thank you all for attending and for your participation and cooperation. And we look forward to seeing you in our next conference in person.